Good morning. Thank you for joining us today. My name is Camden Webb. I'm a partner here at Williams Mullen and one of the presenters today, and I will also be your host for today's webinar. Our webinar, again, is Navigating Operation Choke Point. Today we're going to hear from two of my colleagues and myself. As a matter of introduction, we have Wayne Whitham. He goes by Whit Whitham, myself, and Chuck James, who will be presenting. And in the next 90 minutes, we're going to address the current issues involving Operation Choke Point and other related regulatory enforcement. We're going to discuss how financial institutions as businesses in the targeted industries may identify legal issues and navigate the regulatory environment that has developed in recent years. A couple of housekeeping items. We encourage you to ask questions throughout the program by using the chat feature on your screen. We will answer questions at the end of our presentation. We don't know how many we'll get, so we'll try to get to as many as we can during the time allotted. But please use that chat screen to submit your questions, and please feel free to submit them as we go along. Following today's webinar, we will provide a copy of this presentation to the attendees. We also will are recording today's webinar, so replay will be available, and we can provide replay access at your request. Lastly, if you could please place any cell phones away from your landlines. That minimizes the audio interference, and that would help us today. I'd like to tell you a little bit as well about our firm before we start. We're a firm of about 230 lawyers, and the reason I mention our firm generally is we have some unique convergence of expertise that has put us right in the middle of Operation Choke Point. We have a robust banking practice with about 50 of our lawyers doing something in the financial services sector, but we also have a fairly expansive firearms industry practice. So we have been right in the middle of this issue, and we have really taken on the issues here, and hopefully we'll be able to share our knowledge with you today. I would mention before we start a couple things about our presenters. First of all, Whit Whitham, he's been representing banks since the early 80s and really does everything on the regulatory and business side of the practice for banks, including SEC matters, FDIC and other prudential regulation matters, boardroom issues. And Whit began tracking Operation Choke Point really before anybody knew exactly what it was, at least outside the government. He began looking at this in 2013 and has kept current on that. A little bit about my background. I'm from a litigation practice. I have two areas of concentration, that is banking law and firearms law. This is obviously a particular interest to me. And then Chuck James, he co-chairs the firearms industry practice with me, but he also is a key member of our white collar and investigations practice. He is from a law enforcement background. He was the Chief Deputy Attorney General of the state of Virginia. And in his role, he has worked very closely with banks on regulatory issues as they become corporate investigations and those sorts of matters. So that's our team today. We look forward to discussing with you the Operation Choke Point over the next several slides here. And we're going to start with Whit Whitham, who is going to present and begin with telling you about the background of what we're talking about.
Thank you, Camden. Good morning, ladies and gentlemen. We have a diverse audience today. We have a number of bankers listening in. We also have business people on the line and representatives of trade groups on the line, which I think indicates that there's interest about this issue outside simply the banking industry. For the bankers listening in today, we're going to do our best to dispel what I believe is some confusion about Operation Choke Point. And for the non-bankers listening in, I hope we are able to give you some understanding of what your banker is dealing with. As Camden mentioned a few minutes ago, I first started seeing the word choke point back in 2013. I was preparing to give a presentation to a bankers convention, and one of the things I was looking at was a controversy brewing in New York State, where the Attorney General of New York was upset that an Indian tribe from South Dakota was sponsoring an internet payday lending business that was reaching residents of New York. And of course, its interest rates far exceeded New York's usury limits. He attempted to shut them down, to stop them from doing business in New York. They said, "We are a sovereign Indian nation. You have no jurisdiction over us. Buzz off." Not to be deterred, he decided that the way to stop them from doing business in New York was to shut off their access to the ACH network. So he began writing letters to banks, warning them of the damage to their reputations and various other things that might happen if they continued to provide access to that business. The Attorney General of New York referred to the banks as the choke point, and I think that's the first time I heard that word applied. There also in 2013, which I think maybe was a harbinger of things to come, a case that the CFPB brought against a payment processor named Maricord. It evidently was the payment processor of choice for credit repair companies. The CFPB basically shut it down in 2013 through fines and the like. And its allegation was that the payment processor, Maricord, should have known that its customers, the credit repair companies, were helping themselves to client money before they were entitled to do it. So they were damaging consumers. So that is what I began to see a couple of years ago, and of course it's become quite notorious since then. But I think it's a good idea for everyone, if we're going to talk about Operation Choke Point, let's try to understand what it is and what it is not. What it is, it's a Department of Justice program, and it's designed to put certain merchants and service providers out of business by choking off their access to banking services. Most businesses, of course, can't operate unless they have access to banking services and a bank. So it's a DOJ program. It's not a program that is being carried out by the bank regulators. I would distinguish it from FDIC guidance on doing business with third-party payment processors and other high-risk, so-called high-risk businesses. We're going to talk a lot about that today. It's not the same as the Bank Secrecy Act, which requires banks to report certain criminal conduct. And Operation Choke Point is not the same as the USA Patriot Act, which requires banks to have a customer identification program. So at the risk of confusing everyone, I'm going to try to explain just what Operation Choke Point is and how the DOJ uses it. It's a tactic based on Section 951 of a federal statute called FIREA, and it's used to make civil penalty claims against banks whose customers commit crimes against consumers. Those of you in the banking business may recall FIREA. It was the legislation passed in 1989 to address the savings and loan crisis. No one really paid any attention to this Section 951 until a few years ago when some career lawyer in the Department of Justice figured out how to use it in this context. I'll point out that these civil penalties that the DOJ is seeking and collecting don't go to redress any consumer harm. The DOJ gets to keep the money. But here's how the argument goes. This is the Department of Justice or government argument. Section 951 allows the DOJ to seek a civil money penalty from anyone who commits a crime against a bank or who commits wire or mail fraud affecting a bank. The government doesn't have to prove that a crime was committed by the typical beyond a reasonable doubt standard. It has a lower burden of proof. So this is really, it was intended originally as an additional tool of the government to go after people who commit crimes against banks and hit their pocketbooks even if they can't necessarily convict them of a crime. The government's argument goes on to say that you participate in the fraud if you know your customer is using your bank's services to defraud someone else, and yet you continue to do business with him. In many cases these days, the customer's fraudulent conduct is wire fraud or would amount to wire fraud. And here's where the argument gets a little weird. The DOJ says that the customer's crime affects the bank even though the bank isn't the victim of the crime. The crime affects the bank in that the bank is risking its reputation. And that is how the crime of wire fraud affects the bank. So it's really the bank's own action that affects itself and is being used by the government to attack it. So we're all happy to know now that banks have a partner to help them protect their reputation from themselves. That's what Operation Choke Point is. So far, the Department of Justice has announced Operation Choke Point suits against 3 banks. There have been other banks who have voluntarily settled with the DOJ, but I think it's interesting that really only 3 of these lawsuits have been filed, as notorious as this program is. The first involved a bank, a relatively small bank in North Carolina, 4 Oaks. It settled its lawsuit last year for $1.2 million. And in that case, the Department of Justice alleged that the bank allowed a third-party payment processor direct access to the ACH network. The processor then illegally processed debits on behalf of, you can see it, fraudulent internet payday lenders, gambling companies, and the like. The complaint against 4 Oaks indicated that it received numerous warnings of various types from regulators and from others about this relationship. It ignored the advice that it received and continued to do business with the third-party payment processor. And that is what brought the suit against it from the Department of Justice. The second case was just last month. It's interesting that there was a hiatus from January of 2014 to March of 2015 where there were no Operation Choke Point suits filed. The second one was settled last month for $4.9 million. It involved allegations similar to those against Four Oaks. The banking relationship, again, in that case, was with a third-party payment processor, not with a merchant. The third case also settled last month, and it's interesting that both these cases involve banks in Irvine, California. I'm not sure just why that would be, but those are the facts. In that case was similar to the first two. It involved another third-party payment processor, but this had an added twist here. The top executives of the bank were investors in the third-party payment processor that evidently was ripping off its own customers. Now, I would say most banks would not do this. I don't know of any bank that we work with that would do what these banks did, or that they would cut their customers off fairly early in the process when they receive warnings or when red flags have been raised. To put this in some historical context, to me, Operation Choke Point really is a subset of a larger undertaking by bank regulators to exercise some control over who may receive banking services. And these efforts go back quite a while, many years. I would take you back first to 1998, when all of the federal bank regulators proposed a Know Your Customer rule. And that rule would have identified the source of funds of bank customers, required the bank to determine what normal and expected transactions would be, monitor transactions, and, when appropriate, file suspicious activity reports. And here's what the release for the proposed rule said. The purposes of adopting the Know Your Customer rule are to protect the reputation of the bank, to facilitate compliance, and to protect the bank from becoming a vehicle for illegal activities perpetrated by its customers. I would say this statement was made at a point in the process where the bank regulators were catching a lot of flack over this proposed rule. So this statement really was made largely in defense of a proposal they had made that was proving to be quite unpopular. But there are a couple of themes here that are worth noting. The regulators think that they're going to help the bank protect the bank's reputation and protect the bank from becoming a vehicle for illegal activities. After backlash from consumers on privacy grounds and banks on cost grounds, the proposed rule was withdrawn. I find it maybe slightly quaint that this rule was withdrawn partly on privacy grounds. Keep in mind, again, this was 1998, 1999. It was before the 9/11 attacks and the Patriot Act and customer information programs and the like. But the consumer organizations were against banks finding out that much about their customers. That, of course, is history. In 2001, the USA Patriot Act was adopted. It was in the oven ready to go right after 9/11, and it does require banks to adopt customer identification programs that are quite elaborate. One thing worth noting here, because this is the law, banks are expected to know a lot about their customers and what their customers are doing. And in some cases, in some of the Operation Choke Point lawsuits that the DOJ has brought, it's been alleged that if the bank didn't know what its customer was doing, the bank should have known what its customer was doing, and it points to the customer identification program as the basis. 2002, the FDIC announced that it will cite state non-member banks excuse me, for violations of Section 5 of the Federal Trade Commission Act and take action when it discovers banks engaging in unfair or deceptive practices. This is really, I think, the first hint to me that bank regulators are starting to focus on unfair and deceptive practices of banks. If you were to read this release, you'd see the language is fairly strident, but there's no suggestion here that the bank regulators would impose derivative liability on banks. That is liability when the bank's customer is involved in unfair or deceptive practices rather than the bank itself. In 2004, the FDIC and the Federal Reserve affirmed their authority to take action against banks when they discover unfair or deceptive practices. Okay, we now move to 2008, and we see the first in a series of FDIC releases. And these releases begin as warnings or caution to banks about doing business with third-party payment processors. And the quote I've noted here, financial institutions that do not adequately manage these relationships may be viewed as facilitating fraudulent or unlawful activity by a payment processor or merchant client. This is going beyond what the FDIC said in 2002. This is not saying that it's going to hold the bank responsible for the bank's own conduct, but that it may hold the bank responsible for the conduct of the bank's customer. In 2011, we now see the infamous FDIC list of high-risk merchants. And maybe we'll just take a second to let everyone look at this. It's pretty remarkable. It was part of an article that appeared in the summer 2011 issue of Supervisory Highlights, and I'm sure that they regret ever letting that article see the light of day. I don't know where in the world this list came from and how you were lucky enough to avoid getting on it, or who it was that decided that you would be on it. I'm sure we could all look at the list and wonder why some businesses were left off. I had someone try to sell me vinyl siding for my house a number of years ago, and I really thought he was trying to take advantage of me, so I looked in vain for vinyl siding salesmen on this list. They're just not there. But I think one thing this does, and we'll talk more about this as we go along, but it sort of took the covers off what the bank regulators were really thinking, in that this goes well beyond third-party payment processors. That list, again, was published in 2011. What you'll see as time goes by, the FDIC statements become stronger and stronger. And the language they use really, in many ways, it's similar from year to year. But what is interesting about this statement, which it made in 2012, is that a bank that fails to adequately manage these relationships may be viewed as facilitating the client's fraudulent activity and thus may be liable for such acts or practices. Financial institutions must recognize that they face liability under Section 5 of the Federal Trade Commission Act. What that really means is the FDIC is saying, we will sue you under the Section 5 of the Federal Trade Commission Act. That's not a statute that allows individuals to bring lawsuits. And this goes well beyond what the FDIC said in 2002 when it was alerting banks to the risk of having liability under the Federal Trade Commission Act for their own acts. This is saying that the FDIC might sue banks if they fail to police the conduct of their customers. We come now to 2013. This is a letter, I'll promise you, that the Chicago Regional Director wished had never seen the light of day. You can bet he didn't think it would. But this was a letter he wrote to the board of directors of a bank, and I'll let you take a second to read it. But what he's doing is telling a bank that providing banking services to payday lenders is unacceptable for an insured depository institution. And for those of you who don't work for banks, an insured depository institution is a bank. And I would say that you shouldn't think for a second that this statement by him was a one-off. I don't think that's the case. I think it's symptomatic of an attitude that dates back to at least 2002 in the FDIC. And again, this has nothing about third-party payment processors. You'll see in a minute the FDIC tries to take the argument back there several times, but clearly that's not what they're talking about here. The next quotation is not from a bank regulator, but it again is evidencing what I would say is an attitude that's fairly widely held in the federal government. Okay, as everyone knows, last year all hell broke loose. I think especially in the House Banking Committee, people began to hear about Operation Choke Point, and there was confusion about whether the FDIC was responsible for Operation Choke Point or whether it was the Department of Justice or whether they were in cahoots or just what was going on. But late last year, the FDIC tried to unring the bell. It's sort of, unringing a bell is easier said than done. And I'll give you a second to look at this statement from them. It says that publishing the list of high-risk merchants really was a mistake. It led to misunderstandings. They never really meant that banks were prohibited or discouraged from doing business with anybody. And it's really their policy that if a bank properly manages customer relationships, they're neither prohibited nor discouraged from providing services to any customer operating in compliance with applicable law. The loaded phrase there is operating in compliance with applicable law, and we'll talk about that in a second. One thing I'll just mention because I think it's amusing. I was preparing to give a presentation to some bankers on this topic again a few months ago, and I was pulling together my materials, and I was trying to lay my hands on that article in Supervisory Insights from the summer of 2011, and I found it on the FDIC's website because, you know, that's the article that had the list. So I looked and looked and looked, and I couldn't find it, and I knew it was there. I knew it was supposed to be there, but guess what? It's not. They went back. The article is still dated summer of 2011, but it's not what they published in the summer of 2011. It's been airbrushed to take out the material that led to such criticism. That statement wasn't quite enough. So just last month, the chairman of the FDIC was invited to Congress to talk about this again. And his statement here is very similar to the previous statement that they issued in 2014. That listing categories of merchants led to misunderstandings regarding the FDIC's supervisory approach, resulted in misperceptions, and I think that probably is accurate to say. But again, if you'll focus on the highlighted language, because I think it's important to banks and for customers of banks to understand, you're neither prohibited nor discouraged from providing services to customers operating in compliance with applicable federal and state law. And then he goes on to say they removed the list of examples, so I was glad to find out that I wasn't crazy. I will say that this statement of the FDIC chairman last month had some welcome parts to it. Clearly, the FDIC is sending the message to bank examiners to lay off, to not tell banks to drop particular customers. They have to get permission now to do it. They are not to base any supervisory action purely on reputational risk to a bank, things of that sort. So I think that this actually, what they're saying now is constructive, and time will tell whether or not it has an effect. But I would say the FDIC has exhibited some contrition and is taking steps to improve things. And before we leave this page, you know, one thing I'll point out is that all of this that we've been talking about with the FDIC and its list of merchants and so forth really has nothing to do with Operation Choke Point. It's a completely separate matter, and it's probably a matter of greater concern to banks and their customers than Operation Choke Point would be. So where does this leave us? I think we now have reasonable clarity on banks' obligations under actual laws, things that you can read that are in black and white, that have regulations. We know what they say, and we more or less know what to do to comply with them. What I think we still have, though, is confusion from the FDIC. And it's worth noting, this parenthetical, I think, is worth spending a moment on. The Federal Reserve and the OCC, as you may know, also supervise banks. Some banks are regulated by the FDIC, others by the Fed, and others by the OCC. There are three federal banking agencies. But the Fed and the OCC have seemed to sidestep this mess. So while they may be applying similar pressure in the examination process, they haven't been dragged in front of Congress to explain themselves. They haven't published any lists of high-risk merchants, and so they have avoided it. And what I think is difficult to interpret and apply is the FDIC statement that it's permissible to provide banking services to a customer that operates in compliance with applicable federal and state law. What in the world does that mean? I think there's virtually no way to answer that question. I think it can't possibly mean each and every state and federal law. That would be ridiculous. But what is an applicable federal and state law? The FDIC hasn't told us that, and I think it would be quite helpful if they made an attempt to do that. But as I thought about this, I think, well, what would I say to a bank if a bank asked me? What do they mean by applicable federal and state law? What I'd say is that I don't think you want to bank a business that is illegal. That would certainly seem to go without saying. And I think you don't want to bank a business that uses your facilities to fleece its customers. Those would be two principles that I think would stand a bank in good stead. There are a couple of other questions that I'll leave you with, and then I think Camden and Chuck are going to pick up with. And the first, is it true that a bank can be held liable for a customer's misconduct? And secondly, this is a question that I have seen discussed lately more than one time, and that is whether or not a bank can be held liable for declining to provide banking services to a lawful business. With that, I'll turn it over to Camden.
Whit, thank you. Very good historical context, very good explanation of what Operation Choke Point is and is not. So let's jump on these two questions. And let's take the first one here, because this is a pretty crucial legal issue and pretty crucial for both bankers and these industry participants to understand. Is there liability for a bank for what a customer does? I'm going to go back to what Whit pointed out to you, is the FDIC's suggestion that banks can be liable for facilitating or aiding and abetting consumer unfairness or deception under the FTC Act. Because what you have there is a statement from one of the primary bank regulators saying that if your customer is doing unfair or deceptive things, then you, bank, may be held liable because you're facilitating it or aiding and abetting it. Now, the first thing is, for the lawyers on the line, I think aiding and abetting would be a pretty recognizable legal term. Facilitating may not be. So let's talk about this a little bit. Let's do what all good lawyers do, and let's look at what the Supreme Court has said in this arena. You know, the Supreme Court back in, I believe it was 93 or 94, there was a case called Central Bank of Denver, and someone tried to sue and assert civil liability under the theory that a party was aiding and abetting another party's violation of the Securities Exchange Act. Civil liability, not criminal. The Supreme Court dealt with that pretty straight away, and they said that there is no civil liability under a federal statute for aiding and abetting unless the statute expressly says so. Now, I will tell you, that's pretty straightforward statutory interpretation. The theory that was pushed in the Central Bank of Denver case is you've got a Securities Exchange Act violation, and you got somebody else who helped but was not otherwise subject to Securities Exchange Act liability. And the Supreme Court simply said, look, this is a statute. We read the statute by its four corners. We're not going to find liability unless Congress has said there should be such liability. So, the operative legal principle that we can distill out of what the Supreme Court says is that facilitating, or more accurately, aiding and abetting, the violation of a federal statute is actionable only when the statute specifically allows for it. So then the question we come back to, can the bank be liable for customer misconduct? Well, I think what you have to do is you have to go and figure out what the particular theory of liability is, what the bank is alleged to have done or not done, and see if there is any statutory provision that would allow for essentially assisting in a civil violation. Based upon my reading of the Central Bank of Denver case and how that rationale applies, I would have to respectfully disagree with the FDIC in their guidance because, frankly, if you read the FTC Act, there's simply nothing that implies aiding and abetting liability. Really, before I go back to the next slide, I would just make a comment. The aiding and abetting liability in the FTC arena, that goes back to some cases in the 40s, 50s, and 60s where the courts have held that someone who, for example, produces bingo cards or lottery cards and then the merchant sells them, the person who produces the cards can be liable under the FTC Act for a deceptive act, even though they're not the ones actually selling them. Now, that, in my mind, is distinct from any aiding or abetting. You've got somebody who is directly participating. So I think when you're talking about can a bank be liable for a aiding and abetting a civil violation, it is probably going to be a pretty tough legal standard to meet in order to show that. Now, one other comment, too, before we move on to Dodd-Frank is understand aiding and abetting liability. You've got a standard of knowledge that's in play, and this goes to the know your customer and all that sort of thing. Aiding and abetting liability can't simply be done by putting it in a simple phrase, bumbling into it or not knowing or something like that. It can't even really be what is traditionally known as constructive knowledge of you should have known. Okay? Aiding and abetting liability, when it exists, is based upon something in the realm of criminal intent, knowledge, or another term that I'll talk about here in a second, recklessness. Now, recklessness in this context very often by the courts is referred to as willful blindness or willful ignorance. So really what you're talking about, if you're talking about civil liability for some sort of aiding and abetting, if it were to exist, would require a level of knowledge that at a minimum would be somebody looks at the situation and says to themselves, well, I just don't want to know. And that's really, if you remember that phrase, that's what I remember in the cases that I handle on the recklessness standard of knowledge. If you see facts that indicate somebody said to themselves, I just don't want to know, well, I'll go ahead and do this anyway, that's really the level of knowledge you're talking about. Obviously, far above the level of knowledge and intent than simply failing to supervise a relationship or traditional constructive knowledge. But let's move on to Dodd-Frank. Dodd-Frank has two critical areas I want to talk about. The first one bears directly on the issue of some sort of theory of aiding and abetting, or can a bank be liable for what its bank customer has done to its customers in turn. Now, under Dodd-Frank, there's a very important provision that you should all know about. It is unlawful under Dodd-Frank, and I quote the statute here, and I'll go ahead and read it because it's important language. It's unlawful for any person to knowingly or recklessly provide substantial assistance to a covered person or service provider in violation of the Dodd-Frank UDAP provisions. So let's go through this. I want to unpack this phrase here. Several terms that are used, some of them terms of art, that we need to understand. First of all, what is a UDAP? That is a newish phrase. It's the old phrase is maybe UDAP with one A, but since Dodd-Frank, UDAP with two A's has come into vogue, and what that is unfair or deceptive or abusive acts and practices. In the most cynical view, which I'm a litigator, and that's the view you will get from me, The most cynical view is that enables a court or a party to a lawsuit to come back behind someone later on and say that wasn't fair, that was deceptive, that was abusive. After the fact, you may have complied with all other laws and all other regulations and statutes, but it just wasn't fair. I say that a little bit tongue-in-cheek, but that is what you see in a lot of these cases, is how that is applied, is you look back at the transaction and say that just wasn't fair to the consumer, so therefore there's some liability. So that is something critical to understand. If you're banking a customer who deals with consumers, that probably is going to be a covered person under Dodd-Frank. You may have a service provider under Dodd-Frank, someone who is providing services to someone who deals with consumers. And Dodd-Frank provisions on UDAP are pretty broad and, frankly, a little nebulous. It is my reading of the statutory history and where the Dodd-Frank concept of UDAP came from. It is intended so that if there is something that just wasn't fair to a consumer or deceived a consumer or was abusive, it's a broad net that could lead to liability later on. So what does that mean for a bank? So let's say you're banking a company that deals with consumers. You could say it's a used car dealer, something as simple as that. And let's assume the fact the used car dealer is doing something that puts them under a covered person status, for example, maybe a buy here, pay here financing arrangement, something like that. What in the world is substantial assistance? I will tell you, it's not defined in Dodd-Frank. It's difficult to just look at the cold statute and understand what the substantial assistance might be. Could it be the banking relationship? Could it be a floor plan financing to the used car dealer? Could it be as simple as a business banking account for the used car dealer? Candidly, these are unanswered questions, and we just don't know because there's not been any interpretation of that phrase. But I do think, each word of the statute is important, as the courts will say, and you have to be assisting in some way, and you have to be, that assistance must be substantial. So I'll put that to the side for a moment. On the next slide, I'll bring that issue up again, but understand that substantial assistance is one of the keys to there being potential liability under Dodd-Frank. Now, how about those two phrases, knowingly and recklessly? Again, no definition in the statute. However, these two terms are used. I wouldn't even know to tell you how many federal statutes use those two terms, and use those two terms in the knowingly or recklessly phraseology. My view is that what that needs to be read as is knowing, as in you actually knew of the violations, or you were reckless. Again, as I described it, facts that would indicate that the party looked at the situation and said, well, I kind of understand what's going on, but I just don't want to know. I want to take affirmative steps to avoid actual knowledge of what's happening. So in this situation, it would seem to me that under this provision, a bank would be at risk under Dodd-Frank if there were enough facts to indicate that their customer really is taking advantage of consumers. Whit mentioned knowing that your customer is fleecing its customers. That, in my view, would be the correct reading of this Dodd-Frank provision. Let's go on to something else, and that is I want to also talk very carefully about Dodd-Frank's definition of a service provider. That's very important because Dodd-Frank covers service providers. You have a covered person under Dodd-Frank, and that would be someone who is actually giving the services to the consumers. Then you have the service provider. Okay. Now, let's go back to this. Before I get to the service provider, let's go back to the covered person. I mentioned the used car dealer situation, and I want to continue to use that fact pattern. Understand, of course, under Dodd-Frank that a covered person is providing a consumer financial service. For example, I mentioned the buy here, pay here, which is a financing arrangement that is particular to the used car industry, from my understanding of the breadth of that product. But understand that, for example, if you're a bank and you see that your used car dealer client is rolling back the odometer, for example, that's not a financial service or having anything to do with Dodd-Frank. Could be other legal issues, but just for clarification, when we're talking about this, that's what we're talking about, is the financial service. So what is a service provider? It's anyone who provides a material service to a person who is covered by the statute. Okay, and it also relates back to covered person. A service provider provides a material service to a covered person. Lots of alliteration in that sentence. So, material service. Again, something not defined under Dodd-Frank. What is a material service? Well, the definition of material service does have some guidance. From that guidance, it appears not to include banking services, but it's not entirely clear whether it does or not. Okay? I want to talk about a sample case that has just been filed, and hopefully we can use this to illustrate this a little bit. This case is only a month old. The CFPB filed it in the Northern District of Georgia, and it named a large number of defendants. Now, I've checked the docket on this as of yesterday, and there's not even a responsive pleading from the defendants yet, so all we have is the CFPB's position to go off of. But I do think that's important. For those of you who deal in the consumer finance world, you know the CFPB is the 800-pound gorilla, so what they have to say is very important. Now, let me discuss the facts of this case as they are alleged in the complaint, and again, that's all we have so far. So the CFPB alleges that a number of companies were debt collectors, and they had various different names. Universal Debt and Payment Solutions, the first named defendant, was one of the companies. There are about, I believe, 7 companies total named as debt collectors. All of the men are related. The principals of the companies were named as defendants as well, and they were both in the collection business, and also, if you're familiar with the way that business works, they were also in the debt buying business, where they would buy stale debt. And they appeared, according to the allegations, to be some of the debt collectors that are, well, to put it impolitely, on the lower end of the scale, perhaps, because they were collecting payday loans and title loans and things like that. So they were, for example, they would buy stale debt that was a leftover payday loan from years ago, and it apparently was a big operation because the allegations, at least, contend that millions of customers, millions of consumers were contacted. Now, they didn't just name the debt collectors. They named a telephone broadcast service provider, as they call it in the complaint, and this company does what most telephone marketing companies do, which is they provide services that allow automation of calls to numbers provided by their customer or their client. So these debt collectors, according to the complaint, would provide the contact information to the telephone broadcast service provider, and that service provider would make the calls on an automated basis. They also allege in the complaint that the service provider, telephone broadcast service provider, knew the script because they incorporated the script into the phone call of certain things that would be said to a debtor by an automated voice, those things being deceptive statements and whatnot. They did not stop at naming the telephone broadcast service provider. They also named payment processors, and there were 4 payment processors named. Now, in a payment processor situation with a debt collector, what that is when a consumer gets a call, they receive a call saying you owe $58 from this payday loan or whatever it is. The consumer then calls back and says, well, it's only $58. I guess I'll go ahead and pay this off. I've got this credit card. And then the payment processor would handle that transaction, and then the money would flow from the consumer through the payment processor to the bank where the universal debt and the other debt collectors had their accounts. So that's the situation. Is you've got payment processors that are accepting the payments, debt collectors collecting the debts, and the telephone broadcast service provider making the calls on an automated basis. Now, CFPB has good lawyers. They picked what appears to be, from the complaint, a good case for them because of the bad facts. There are lots of red flags here. There's the stale debt problem. There's the purchasing of stale debt problem. There's the, as they allege in the complaints, threats of criminal prosecution for not paying your debt. Anybody who's been ever advised a debt collector of what's legal and not, you can never do that. Threats of jail time for not paying. We'll sue you today if you don't pay. So they picked a case with good facts. But here's the interesting thing, is the CFPB considers the payment processors and the telephone broadcast service provider both as meeting the definition of service provider under Dodd-Frank. Now understand, this is a bit distinct from the substantial assistance problem. This is being defined as directly covered by Dodd-Frank, okay? So the CFPB apparently believes that the payment processors and the telephone broadcast service provider were providing a material service to someone who was violating Dodd-Frank. Now, let's take the difference between a telephone broadcast service provider and a payment processor meeting that definition. The payment processors are really a step removed from the situation, because the telephone broadcast service provider, they had the script. They had the opportunity to look at what the message was. They automated the calls. In fact, some of this, the way I read the complaint, could be a violation of another federal statute regarding automated calls. So they're much closer to the situation. The payment processors, however, are a step removed but still providing material service. What the CFPB contends is these payment processors violated their own internal policies by accepting payments for stale debt and for other debt. For example, one of the merchant agreement provisions says you can't use a credit card to pay off debt. CFPB contends that that essentially, the way I read their complaint, says that's given you enough level of knowledge to know that you're providing material service for violations of Dodd-Frank. Now, the curious thing, who is the bank for the payment processors? That's the open question. And we have no idea where this leads. We have no idea where this case will go, what its fate is. But that is the interesting question, is who's the bank? Is the bank going to be alleged to be a service provider in a subsequent suit? Is the bank going to be alleged to have provided substantial assistance? And then the question immediately becomes, what level of knowledge does the bank for the payment processors, do the banks for the payment processors have of what's going on here? And that's an open question. That is, Chuck and Whit and I could talk all day and not come to the answer for that, to that for you. But that's the issue that's out there for the banks, is when do you get to the level of knowledge that you can be held liable either as providing substantial assistance or even perhaps being a service provider? So let's then turn, I want to talk about one other area for potential liability for what your customers do, and that's the FDIC cease and desist powers. Now, under, this is Section 8B, or it's 12 U.S.C. 1818B, the FDIC has cease and desist powers. That includes an order of restitution. Now, that's, in my legal mind, two different things, cease and desist versus pay money, but that's the way it goes. Importantly, there are some legal constraints to this power. First of all, it appears clearly in the statute is when there's a violation of the law, and then secondly, as in the statute, there's an unsafe or unsound banking practice. Now, violation of the law, we understand that there should be some law you can point to as a violation, and the unsafe and unsound has been subject to some judicial interpretation. As you read the cases, what this means is that a bank has committed, or importantly, a bank principal, because it applies to individuals too, has committed an unsafe or unsound banking practice when it has committed conduct that is contrary to accepted standards that presents an abnormal risk or loss to the bank or its shareholders. So that is what we have in front of us. But again, this harkens back to the point Whit made, which when the FDIC chair says complying with all applicable state and federal law, what does that mean? And when they have the FDIC taking the position that you can have aiding and abetting liability under the FTC Act, do you have a violation of the law when your customer is committing an unfair trade practice and you've somehow evaded and abetted it? So this is a little gray area. What I would tell you, though, is before we get to the next slide, is that you do have some legal constraints on what the regulatory power is here. It's just we also have a few open issues that are unfortunately not going to be answered in the near term. So how about any good news? Do I have anything good to tell you? My colleagues tell me, being the cynical litigator, I never bring good news, but I guess I'm good in a pinch. But let's talk about the good news. The applicable legal standards, it appears to limit civil liability to situations when the bank knows of a customer's violations of the law or is willfully blind to those violations. Those are two critical standards and something to bear in mind. The cease and desist authority should be limited to situations where the bank is breaking the law or committing acts that present a significant risk to the bank. Again, we've got to be careful about the definition of a violation of the law, but that should be a constraint on the cease and desist authority. The very good news is there is absolutely no categorical prohibition on doing business with certain industries. That is critical to understand. If you have a regulator tell you that you are doing business with an FFL firearms dealer and you have to stop because they're an FFL firearms dealer, that in our legal interpretation is an incorrect statement of the law. And in fact, there are specific standards the FDIC has introduced that the regulators must meet, which includes running it up the chain of command before any such regulatory guidance, let's say, or insistence by the regulators can be made upon a bank. Let's talk very quickly, and I've taken a lot of Chuck's time, and I apologize, but I want to walk through this because this is from the industry's perspective. Can banks be liable for declining customers? That's crucial to understand. Now, this is the general principle to understand above all. Any business may refuse service to anyone unless some specific law states that such refusal is prohibited. What's the most common one you can think of? Anti-discrimination. And the very, very current example I would point you to is out in Oregon, for example, just I believe on Friday there was an order issued in the case where the baker refused to provide a wedding cake or something for a wedding, a gay marriage. That is an example. That's the example to think of when you think of, well, I don't want to deal with this person, but the law says that I can't not deal with them. Okay. But remember, refusal to deal as a general matter is just not a basis for liability. Okay. That's important to the industry because, candidly, obviously representing the firearms industry, I would love to be able to tell you, well, gosh, if somebody turns you down just because you're a firearms dealer, that's a legal problem. It may be a problem in other quarters, but legally, I do not see the liability for a financial institution making that decision. That really is left to the market to decide whether that's a good bank policy or not. Let's continue this conversation and talk about the legal basis of this. Understand that the relationship between a bank and a customer is primarily governed by contract. We have a world of laws governing banks, but when you look down to the very bottom line, the relationship between a bank and a customer is a relationship governed by contract. Now, contracts can be a deposit account contract, a loan contract, something like that, but it will almost always be governed by contract. Now, go back and read your bank contracts. Go back and read your deposit contracts. Go back and read your loan contract. There is almost always going to be some provision that allows termination of the relationship, declining of services, something like that, and the bank customer usually doesn't have a whole lot of recourse for that. I'm going to give you an example. I say a case. I litigated dozens of cases like this, where the bank refused to advance additional funds on a loan. And the customer sued and said, gosh, you know, if you'd advanced the additional funds, my project wouldn't have failed, therefore it would have closed on time, therefore I wouldn't have lost my shirt, so bank, you got to pay for it. Except for really unique facts, those cases failed, almost all of them, because you got to look at your bank contract. You got to look at what your contract says, and ordinarily the contract says the bank can decline services. What about if you're not even a customer yet? What if you go to the bank and say, I want to start a AR manufacturing company, and the bank says, I'm sorry, we just don't deal with the firearms industry. You've got even fewer rights. The bank is free to decline the service to the customer. On the other hand, the banks that decide to bank certain industries may do so, and their obligation is to look at the specific risks of the specific customers, not to shun entire industries. They have no obligation to do so. The FDIC confused that situation a few years ago, but they have now clarified that there is no overriding prohibition on dealing with certain industries. So, then the question is, the overriding concern for us as lawyers is how do industry participants and the financial services industry navigate this, and how are the financial services available to the industries in such a regulatory environment? And with that, I'm going to turn it over to Chuck, who is going to talk a little bit about that subject.
Thanks, Camden. Well, Camden has mentioned that he's a litigator, and that makes him all but inherently cynical. And as a former prosecutor and a current defense attorney, I probably am even further along in that spectrum. But there is light at the end of the tunnel, because what we want to do is, recognizing where we are now, find strategies that both those in the banking industry and the potential customers can implement in order to make them, to distance themselves as much as possible from the civil liability that we talked about earlier for aiding and abetting. And so really what you want to do, whether you're a bank potentially exploring a new customer relationship, or a startup or existing business engaging in contact with a bank, really have an ongoing dialogue. So let's begin with the premise that banks are expected to know their customer. And we have to concede that in light of the current regulatory environment, that's especially the case. It really does put an increased onus on the bank to know their customer, and in some cases, as we've noted here, to know the customer's customer. And so there are two basic points at which a bank will have this opportunity. The first, of course, is for a new customer when beginning a new banking relationship. And the second, of course, is when an existing client, existing bank customer, may want a new service or product. So, as Camden noted, the concern here is less about a customer taking legal action against a bank. The bigger concern for our banking friends on this call is going to be the regulator action. And we want to make sure we can put as much distance as we can between our bank clients, our retail clients, and this sometimes hard to understand line about where aiding and abetting can begin. For those that have some criminal background, criminal law background, let's be very clear. We're talking about a different aiding and abetting standard than is typically used in the criminal law context. The law surrounding aiding and abetting in the criminal context is certainly better understood than it is in this sort of relatively new and still emerging area of banking law. So it really comes down to the due diligence that needs to happen and the conversation that needs to happen from both perspectives. And as Whit noted, we've got a good array of folks on the call, and so some of this will be directed to our bank clients and bank friends, and some to the retailers who may be customers. But the dialogue has to be between those two parties. One of the things that we should also mention here is, there's going to be a bit of the business judgment rule. There's going to be a bit of the banks deciding, unless customer is in a particular class that they have the right or decision to reflect on whether or not to engage in certain loan products. And so that's really an opportunity, particularly for an industry that's near and dear to us as part of our firearms practice. The firearms industry is really looking for a bank that wants to deal in this area, that wants to work with an FFL or a owner of a range or someone who provides security services, and really helping them understand what your business is, what your model is, what your culture is, in hopes of getting the banker comfortable with working with you. Where a banker may have a lot of experience dealing in commercial real estate, they may be very adept at mezzanine financing, they may be very comfortable in any other number of areas, but this is something new to them. And so that dialogue can be helpful. And, for my clientele, working with folks on compliance in a proactive manner is always preferable to responding to a regulatory matter. And so we cannot underscore that enough, the need to have that dialogue. So let me give you an example. I'm going to give two examples, and this one is hopefully relatively close to the mainstream. You can see it there, it's on the screen for you, but you're a banker or you are Mr. Jones, depending on where you most closely align. Mr. Jones comes in, he's a potential bank customer, and he wants to open up a new business account for a startup, Acme Ammunition. He would like traditional business checking, credit card for his business, and he's already properly licensed under, for this example, a Virginia, North Carolina state regulatory regime. So what are the discussions that need to happen there? And if you're a banker, you may be aware that you just heard this phenomenal presentation by Whitham. He noted that there was a list that was circulated and since retracted, and notwithstanding certain policy changes, you see that the ammunition industry and firearms retailers were on that list of industries that required this extra scrutiny. So what are the things you want to discuss? Well, there's a handful of them. And for the sake of this discussion, let's put politics and policy aside. We're going to be agnostic as to, and we're not going to debate policy here. We're just looking at a lawful business that is perhaps subject to this additional scrutiny. Well, the questions that you would want to ask as a banker are, what exactly will Acme make and what will they sell? You'll want to make sure that they are in full compliance with both state and federal regulations. You'll want to know what sort of controls that they have. That could range everything from what are their ATF regulatory compliance protocols to what is their physical security for protecting firearms and ammunition both during business hours and afterwards. And you're going to want to know a little bit more about their business model, their ownership, and frankly about their customers. These are all things that are going to help you as a banker be more comfortable with an industry that you may or may not have some experience with. And these are things that customers in this area need to be prepared to address, perhaps proactively, in an effort to forge this relationship or to take it to the next level by seeking additional products from your existing banker. One thing that folks in the firearms industry are well aware of, because it's been a hot topic, but bankers may not be, is there's one thing that we should know here is that folks in the firearms industry are a highly regulated industry, perhaps more than almost any other industry out there, and that's saying a lot to a banker. But by way of example, under ATF rules, for every firearms background check that is done prior to the sale of a weapon, even if that transaction ultimately does not go through for one reason or another, that firearm retailer has to hold on to a form. It's called an ATF Form 4473 for a minimum of 5 years. And that form is going to contain driver's license or personal identification number for the customer or the potential customer. It'll include the results of a criminal background check that's run through a FBI program, a lot of other personal information about this customer. So when you're talking about knowing your customer and knowing your customer's customer, that form available for 5 years is a good example of the kinds of regulatory requirements that are on an FFL that really do sort of speak to the level of supervision they have from their enforcement agency. And for a completed transaction, that is where a firearm ultimately does go to the customer, they are under an obligation to retain that record for 20 years. And that's just one of the examples that a FFL may be able to offer to a banker in order to demonstrate their level of compliance, what their compliance plan is like, and how they're going to ultimately be a good credit risk given that oversight. So let's fast forward. Let's assume that things go swimmingly, that you're 2 years into this relationship and Acme Manufacturing has done well, and they have been making their own ammunition and reselling other manufacturers' firearms. They'd now like to move into a new area that is manufacturing and selling their own line of Acme firearms. They have been, as I said, been a good customer. And Mr. Jones now comes in and wants some capital in order to build out his manufacturing capacity. So the question then becomes, what are the things that we can do to get Mr. Jones and his banker comfortable? Technical glitch there, or user error, I should say. So what are the considerations that we need to have here? Well, really, it's the same questions that we had initially when the relationship began. What are the regulations that are going to control the manufacturer? How do those differ? Will they serve as a pawnbroker? Will they have certain registration requirements under state or federal law as a pawnbroker or any other line of business that they might go into, including as a manufacturer? Another thing that should give both folks in the industry as well as our banker friends some comfort are things like the Protection of Lawful Commerce in Arms Act. That's a statute that bars civil liability against firearm sellers and manufacturers for crimes that may be committed with their products. And so to the extent a banker is concerned, if I'm going to extend financing to Acme Firearms, and should Acme Firearms find one of their weapons used in a crime of violence, what is Acme's exposure and what is my exposure if I am deemed to have extended that loan or even aided and abetted? But there are statutes in place that are going to provide protection both to Acme and potentially to the bank. And those are things that should give bankers comfort, the cautionary tale that Whit and that Camden discussed notwithstanding. And there's any number of other things that we can do to demonstrate why a manufacturer or anyone involved in firearms can still be a very good credit risk, how their controls are appropriate, and in the interest of moving along, we will save those for follow-ups. I want to give you very quickly an outlier case, and that is medical marijuana. There are any number of states, approximately half of the states in the United States have some form of decriminalized or legal marijuana, usually medical. But that's not to say that marijuana is legal under federal law. There's been some language put out by the Department of Justice and FinCEN that is deemed, quote, clarifying their earlier letters where they said it's illegal and we reserve the right to prosecute. But as Camden noted earlier, when the government says it is clarifying language, that is probably typically code for we are reversing course and saying the exact opposite of what we said before. And so to the extent a banker does not have confidence that when the government says they're going to, quote, address marijuana activity through enforcement of their own narcotics laws and defer to states, that probably is not going to give most banks comfort in extending credit and credit services to the marijuana industry, though legal in half of the states in our great union. So it's probably not going to get you comfortable, but those are some things to be considering, and I'll now turn it back over to Camden.
Great. Well, thank you, Chuck. Very informative. That wraps up the presentation part of the talk. We do have some questions that we've received that we want to go over and give us a chance to answer them because it's some good illustrations. I think the one, and I think this is a question for Whit, curious as to what do you see that is ahead in the regulatory scheme, and what can we anticipate next regarding both Operation Choke Point and the regulatory action by FDIC and others?
The Department of Justice has not backed down 1 inch on Operation Choke Point, but again, I would point out that its impact, I think, has been less than the impact of the FDIC and its guidance that it's put out over the past 5 years or so. And I think the FDIC has essentially backed down from the position that it was taking up through, say, 2013. I think banks will continue to be pretty careful about who they will do business with, and to make sure, quite apart from what the FDIC says and quite apart from Operation Choke Point, that their bank is not providing services to someone who has a higher likelihood of, let's say, of being entangled with law enforcement.
Great. Okay, thanks, Whit. All right, next one I think is one that appears to be coming out of my area in the presentation, so I'll tackle this one. It says you spoke of aiding and abetting as a legal term. Is there a legal standard, or what is the legal standard for facilitating a violation of the FDIC Act? And candidly, I don't think there is a way to define that. What does facilitating mean? That appears in an FDIC guidance. It does appear in the alternative, facilitating or aiding and abetting. So if you're reading the guidance like you would read a regulation or a statute, it has to mean something, right? But I just don't know what the legal standard would be to apply to facilitating. I think you got to go back to that Supreme Court case about the Security Exchange Act liability, that you're going to have to look at the statute in question, and you're going to have to see if there is some aiding and abetting or other form of liability other than the person directly violating the statute. And if that Supreme Court case rules, then I don't think there is any room for liability other than what the statute dictates. So, another question, this is Chuck's area, it looks like. So you talked about the medical marijuana cases. From a banker's perspective, with that industry, you said there was a clarification or statement that they would not prosecute. How good is that, considering we got a current administration and that administration will change in January 2017, and how can we rely on that?
Well, my experience is that bankers by nature tend to be relatively conservative and risk averse, and for that reason I would not expect most bankers to put a lot of long-term planning and reliance on that statement. We are at any given point one election, one policy change away from a reversal in course, and we've seen within the course of this presidential administration a 180-degree turn on their statement on enforcement, so we can only imagine what might happen in a new administration, irrespective of the party. So I don't have a lot of confidence there, and I think as a result we're seeing folks who are seeking services, financial services, being pushed away from financial institutions and heading to private equity as a result, and I think most banks are avoiding that, and I would expect that to continue for the foreseeable future.
Great. Well, thank you. And I did also we had one comment from our audience I wanted to acknowledge, and I very much appreciate it because it's an issue that I think needs to be on everybody's radar. There is a some legislation that has been introduced in both Alaska and Kansas, which is under the term Firearms Industry Non-Discrimination Act. It would basically restrict the ability to refuse to deal with a federal firearms licensee just because they are involved in lawful commerce and firearms. And my understanding from the comment is with the firearms being a constitutionally protected activity, that would be the basis or the theory behind the law that you can't refuse to deal with someone just because they are in the business, which is a constitutionally protected activity. So thank you for that comment. That is something to keep on your radar. That would change the answer that I provided regarding the refusal to deal and the ability of a banks to refuse to deal. The last comment I would make, as I said at the beginning, we have the presentation available that we'll send to you. We also have a recording of this that will be available, and feel free to email any one of us to obtain a copy of that recording. If you have any specific questions you'd like to present to any one of us, please do. Our email addresses are there. Our phone numbers are there. Feel free to contact us. I think as you've gathered from the last 90 minutes, I believe we're somewhat knowledgeable of this, but we're certainly passionate about it. So we'll take the time to talk to you anytime you would like. So please contact us if you would like. And so with that, I appreciate your attending with us, and I hope that you learned something. And my overall hope is that we can find a way for the industries and the banks to get together and do business, which is the whole point. Thank you again.